This is the Pharmaverse podcast. I'm your host, Michael Pietrack, engaging leaders from the pharma universe. Hello and welcome to a special edition of the Pharmaverse podcast. I'm your host, Michael Pietrack. And the reason I call this a special edition is because today's guest is our episode 16 guest, Howard Matalon. And if you recall, he's an employment attorney. He's also an executive coach for biopharma executives. And the reason I asked Howard to do this special edition is because since we recorded his episode, the FTC has published a rule that may really change the landscape of non-competes. And so I wanted to pick Howard's brain about how these changes may affect you. So Howard Matalon, welcome back to the Pharmaverse.
Thank you. It's terrific to be here, and thank you so much for inviting me onto the podcast for episode 16. It was very impactful for me. It was impactful for a lot of people. So my humble thanks to you and to the program.
Yeah, we're happy to have you back. So what is this FTC rule and how will it affect people who've signed non-competes?
So I don't want to burst anyone's bubble because things are very unsettled right now about this rule. So the FTC, as everyone knows, is the Federal Trade Commission. And the Federal Trade Commission was directed by the Biden administration to look to see whether or not the non-competes that were affecting the majority of adult employees were violating any of the FTC Act. And sure enough, the FTC determined that Section 5 of the Act was violated because non-competes are a restraint of trade, an illegal restraint of trade according to the FTC. So what did the FTC do? The FTC went ahead and started looking at non-competes. Now, non-competes fall into one of three flavors. And we'll start with the ones that aren't involved first. There's anti-rating, which means you can't steal an employer's independent contractors, suppliers, vendors, or employees. Then there's the non-solicit, which is that you can't take your employer's current or prospective customers. And finally, there's the industry non-compete, which is that you cannot compete with your former employer once you leave for a period of time after you leave employment if that company that you're going to is deemed one way or another a competitor of your former employer. Right. The FTC has gone after that rule. So what the FTC did is it promulgated a rule, and the rule will be effective as of September 4, 2024. And that date's important because the FTC rule applies things differently depending upon whether we're talking about what happened before the rule came into effect and what happened after the rule came into effect. So let's talk about what happened before the time period when the rule goes into effect as to any non-competes that were entered into before the rule was promulgated. Okay. If you are not considered a senior executive under the rule, then the FTC means to do away with all non-competes applying to all adult employees, whether you're part-time, full-time. The definition of a senior executive is someone who is making over $155,000 who is involved with what we're calling policy making. Now, policy making is a very, very broad topic, as you know. I could see that ranging in application from, let's say, your Chief Human Resources Officer making policy by changing the handbook to your Chief Operating Officer and probably anyone who is considered a senior director and up who is actually involved in managing the operations of the business and therefore affecting change. So anyone who falls into that category, the rule will not affect you as to existing non-competes, one that you've already entered into. Now, as to any non-competes that are entered into after the rule goes into effect, the FTC has said all of those non-competes are null and void. It doesn't matter whether you're a senior executive or not. The only two exceptions are, one, that you're an executive who has entered into a new non-compete attendant to the sale of a business. So there's a merger and acquisition, your company is acquired, you get equity in the new business or whatever the compensation is. And because you're entering into this new non-compete attendant to the sale, that non-compete will be enforceable, right? What the FTC is saying basically as a bright line is it doesn't want those who are selling their businesses or involved in the sale of a business to be able to profit by then turning around and competing with the former business they just sold.
Makes sense.
And of course, the other thing that the FTC is staying away from wisely is if the non-compete has to do with customer non-solicitation. So if you have a non-compete that says, for example, that I can't compete with Pfizer and I can't steal Pfizer's customers, the non-compete would be unenforceable as it pertained to Pfizer itself, right? But not necessarily to Pfizer's customers. There, Pfizer would have the right to say, you can't take my customers away. The FTC rule doesn't apply.
Let me ask you a quick question, just as a for instance. A lot of the people that I personally place are field-based representatives that aren't really salespeople. They're more subject matter experts. They're not really privy to like any secret sauce or anything, but they stay in a therapeutic area. If they're an oncology MSL supporting a GI oncology asset, and they want to go to another company that has that, and these people make over $200,000 of total compensation. So in the new reality, a non-compete would be really unenforceable.
So in the new reality, someone who I would say would fall into that bucket, who wouldn't be considered a senior executive, would probably have their non-competes removed. So let's say one of those field reps is out there, they have an existing non-compete, the FTC rule comes into effect, their non-compete should go away. As opposed to a senior director or above who is involved in the day-to-day operations and affairs, is managing a whole group of people, is making decisions on behalf of the company on a regular basis, that person would probably be declared a senior executive and their existing non-compete would remain. Now, if that senior executive were to go to a new business,
like September 5th.
We'll get to what's happening, right? They decide to move. The new employer, if the rule goes into effect, will not be attempting to offer, shouldn't be attempting to offer or to enforce any industry-based non-compete. They can still do a non-solicitation. You can't steal our customers. You have to adhere to our trade secrets, our confidential information. The FTC is going near none of that. Now there is a big asterisk, and the asterisks, if you have a question, I'll answer it before moving on to the next area, which is what's really happening with the rule now, because that's really important for everyone.
But before you go into that, let me ask about non-solicitation of employees, because what happens sometimes is I'll place a vice president of some department, and then their job is to build out that department.
Right.
Is the non-compete still going to be like, hey, you can't go and solicit our people?
Yeah, the FTC did not address anti-rating. The only thing that they said was, if you have some other form of competitive restriction, even a non-solicit of customers, for example, if somehow that provision in whatever agreement that you signed or you're contemplating signing could somehow be construed as a restraint on trade, that it would impact your ability to find gainful employment, it's possible that it would get the same treatment. Very hard to cover all the bases for the FTC, and I think that assuming that the rule goes into effect, this is going to be an issue for years to come, with courts reviewing on a fact-specific basis whether or not a non-compete runs afoul of the FTC rules. You have to remember there are certain states, like California, where non-competes are not enforceable right now, and that includes, for the most part, non-solicitation, because the California courts have ruled that when you attempt to do restraints of trade, like attempting to protect customers, you're also impacting someone's livelihood. So the rule of thumb in California is most non-competes, to the extent anyone tried that, are gone, right? And new employers are wise enough to not even venture into the area.
Is it going to still be a state-by-state decision, or this is going to be a blanket thing for the U.S.?
So here's the asterisk part.
Okay.
There are 3 courts that are currently deciding the fate of the rule. Okay. In Texas, a federal district court has found the rule to be invalid. The business groups that appeared before the court, however, did not seek a nationwide injunction. In years past, we've had nationwide injunctions passed by courts, ruled on by courts, because someone came in and said this would have universal application across the U.S. and asked the court to act in the best interests of all Americans, so to speak. In this particular case, the Texas business groups were only focused on the Texas business groups. Unfortunately, or fortunately, depending upon whether you're employer or employee, the case that would have come right after it in Texas would have sought a nationwide injunction. So the rule right now is enjoined as to these business groups. The court has promised to have a ruling by August 30, which is 5 days before the rule is supposed to go into effect. Yeah. Now, will the court issue a nationwide injunction at that point in time? Who knows? Will it just be a decision that people could wave around saying this rule is unenforceable? It would be obviously the employers who would do that. In Pennsylvania, however, the situation changed just recently, where a federal district court looking at the same rule decided that the rule was in fact a valid exercise of the FTC's authority. So that, and in that case, again, that ruling is not necessarily going to have universal appeal. It applies to the parties in front of it. And then there's another action that started in Florida, and we don't know what the outcome is going to be because it's just underway. At the end of the day, I'm sorry to say to your listeners, I ultimately believe this rule is going to be struck down by the U.S. Supreme Court. And the reason is because the FTC has asserted itself in an area that is typically governed by the states, focused and controlled by the states, even though obviously there's interstate commerce. The U.S. Supreme Court has already shown a predilection for allowing the states to govern themselves state by state, and a number of states have done a very good job of creating non-compete rules and restrictions to regulate the issue depending upon what level you are, how much money you're making, what profession you're in, and so forth. So I believe that the U.S. Supreme Court is going to strike it down, particularly since, not to bore your listeners, but they had a recent ruling about whether they need to give agency deference in the area that the agency has subject matter expertise over. And the court has now determined, reversing precedent that's been around forever, that the courts no longer need to give deference to those federal agencies. So I think the combination of the nature of the rule, the extraordinary relief that the FTC is looking for, coupled with the removal of what they call the Chevron defense, is what's going to cause the Supreme Court to find that this rule exceeds the scope of the FTC's rulemaking authority and ultimately will go away. But what do we do now, right? That could be months from now. Who knows? Will they expedite or fast track it? Will it still go through review by the appellate courts that sit on top of these district courts? Because for sure, they're going to be challenged in Texas and in Florida and Pennsylvania. Sure. Here's my best advice for all the listeners, Michael. If you are in a current position as a senior executive, there's really not much you can do. The existing non-competes are going to govern as long as you're in the role. I would say be wary of any new non-competes that your employer is going to suggest to you after September 4, because I know a lot of employers may actually want to take a fresh look at their non-competes, right? If that's the case, even if a senior executive has an existing non-compete, they could argue that the FTC rule would bar their employers from trying to put a new non-compete in front of them, and that they're going to have to live with whatever they've already signed. That's probably the case for most of the senior executives who would be part of the pharma world. Going forward, if you're looking for a new job, one of two things is going to happen by September 4. The employers are going to revise their non-competes if they have to remove the industry-based non-competes and focus in on anti-rating and non-solicitation as their best protective measures. You're going to see them also try to toughen up their rights and protections to trade secrets, right? Because remember, one of the reasons why non-competes were created as an invention is because employers wanted to create a blanket over the problem of you learning something from them and taking it to a competitor, right? Yep. And you can't lock up what's in your noggin, right? There was a doctrine called inevitable disclosure that had some sway in the past. It doesn't really hold sway anymore. Certainly not with the same kind of frequency or deference courts used to give it, where they would say, well, you learned you were at Coke. Clearly, you know everything there is to know Coke. Now you want to go to Pepsi. You'll inevitably share everything. It doesn't work that way. The non-competes are what they are. It's the writing that you've signed. So I think if your listeners are moving, or viewers, if your viewers are moving to a new employment situation, it's time to have a good hard look at the non-compete, determine whether there is an industry-based one, and talk to the employers about how they intend to address the rule. If you're in a delicate situation where you know the employer doesn't care and is going to try to mandate that you sign it, the truth is that the FTC rule would probably mean that they could never enforce it. So if you have to choose between making things difficult in a new employment relationship and passing on something good, or trying to force change on an employer who's not willing to make change, my advice is, although it's situational, I would probably just look at the documents carefully. Always make sure that whatever the business of the company is very well defined, so that you understand what the employer is asking from you in terms of the non-compete restriction. And then if the FTC rule comes into effect, most likely any industry-based non-competes that are already in a document that you're prepared to sign won't be enforceable anyway.
That makes sense. Yeah. Well, anything else that they need to know? I mean, some of the questions that may be null and void now, for instance, like some of these non-competes are written to be so broad, like can't work in the pharma industry or can't work in oncology or, in the whole therapeutic area.
Right.
Obviously, if that's all null and void, it wouldn't matter. But let's say the FDA, or let's say that the Supreme Court basically knocks this whole thing down and we're back to what we've always known. These non-competes that are broadly written, any advice for people with that situation?
So regardless of the outcome of the FTC rule, almost every state that allows non-competes makes clear that the non-compete must be reasonable in its scope, its duration, and its geography, right?
Okay.
There are some cases where a national non-compete is necessary. The Coke-Pepsi problem, for example, the Pfizer-Merck-Novartis problem, for example. In other situations, however, the court's going to say the geographic restriction needs to be limited to a certain number of miles in the radius of where the business operates. The court's also going to look at the duration of the non-compete, and they're going to look at what the actual scope or content of the non-compete is. To your point, if it is written in a certain way as to say you can't work anywhere in pharma, a court is going to look at that very, very closely to determine if it effectively precludes someone from working. Now, there are a couple ways to deal with that issue. One way is make sure that your severance, whatever that is in your agreement, is at least as long as the non-compete or is as lucrative as the non-compete. So, for example, if you're making $300,000 a year, if you're fortunate enough to have that going on, right? $300,000 is a lot of money. You'd love there to be 12 months of that paid to you for a 12-month non-compete. But we all know that more than 6 months of a non-compete could be a death sentence for you in your industry, depending upon what you've been working on, the fact that you now need to disappear from the limelight in your career. Ask your employer to redefine the business as narrow as possible, particularly if you're in biotechnology or a particular application of, let's say, oncology, where it has to do with a particular drug or a particular application of a drug, rather than saying you can't go to work for oncology. Most employers, to their credit, will actually tell you they're not trying to throw a blanket over the problem and are willing to work with you. The other thing that you can do, particularly for large pharma companies, is you can ask them if they can put an exception in the non-compete to say, for example, if I go to work for another large pharma company, but I'm working in a division, group, or unit that does not compete with your former employer, is it okay to go do that and have that baked into the agreement? I've been very successful at getting that to happen. It happens more times than not. Most employers are looking at this thing. And look, every employer is composed of individuals who are as worried about the non-compete as your viewers are.
Yep.
And they don't want to end up being on the receiving end of the very treatment that they're giving others. So they will absolutely be receptive to a conversation as to how to handle that, particularly prospectively. The other important thing, this is really critical. If you are coming into a business where you have a large, let's say, customer base or sales group, it's incumbent upon you as the employee to come forward and say, these are customers I've had my entire life, from the time that I started in this business, and I want to be able to work with them after my time here is gone. Because while you may enrich the relationships at a new employer, you certainly didn't start with the customers there. So get them to recognize there's a list. I get these customers are mine, and when I walk out the door, they're still my customer, because that could be the difference between a successful lifestyle after you leave a company and starting from scratch.
Here's another curious question that I have. Sometimes I have a client that is hiring people, and that person they want to hire has a non-compete. For companies that are hiring people that have non-competes, what advice would you give to those companies?
So the pattern is what? Give me some specifics.
Like, for instance, XYZ company is a direct competitor with ABC company. XYZ company starts this big build out. Some of the ABC companies employees want to join XYZ, direct competitor. And then the company where people are vacating sends some sort of nasty gram to the hiring company to cease and desist.
Right.
Do those hold any water? Like, should they even look at that?
So first of all, there's nothing, let's say that you are joining a brand new company and there are a lot of employees that wanted to follow. Most non-competes will say you can't directly solicit them to join you. And you can't then join the other company. However, there's nothing precluding those employees, if they're unhappy, from just responding and talking to other people within the company, as long as the individual with the non-solicit is not involved at all.
Applying directly, right?
Right. That person would just say, look, I'm not involved. I can't be involved. If you're unhappy there, talk to my CEO, right? So you're not facilitating anything. You're not involved. You're not engaged. You're not going to say anything about the individual. That individual has to make it there on their own, right? And the fact that you happen to be at this other company may have caused them to rethink their employment, but it won't be the catalyst for them leaving where they are.
This episode is brought to you by K. Bassman International, the leader in pharma and biotech recruiting. When pharma executives need to make critical hires, they go to the experts at K. Bassman, pharma's one-source staffing solution. Visit kbic.com. Now back to the episode. One last question, and then we're out of time, but as far as like if somebody has legitimate non-compete questions, what recommendation would you give to that person?
So every day I'm fielding questions from probably anywhere from 10 to 30 employees about non-competes. And I think it's important, if you have a critical issue about the application of the non-compete, before you either approach the employer or you engage in any kind of self-help, God forbid, talk to an attorney. Find an attorney where you are, find a national attorney, find someone who you believe really understands both the practicalities of the situation and the legalities of the situation, and they can help you navigate your discussions with your employer or your journey out of a company. And by the way, this is just one of a myriad of questions that you need to ask yourself when you're leaving. And this is a separate topic we could talk about another time, but the critical thing that typically trips up employees these days is actually not the non-compete. The critical thing that trips them up is that they somehow are in possession of confidential information their employer after they leave. They use a company laptop, they've backed it up, they use the thumb drive, they have the thumb drives in a drawer somewhere, and the employer finds out that these thumb drives are out there, or other data. That is an absolute no-no. You have to make sure to work with a lawyer if you have critical data to make sure that your existing employer knows that you have no intention of keeping it, you're giving it back, whatever they want to make sure you don't have it is fine. Take that issue off the plate, because it's a tool in the employer's shed that they can use to make your life very difficult if you have any of that information.
Howard, thank you so much for giving us such valuable information. I'm really glad that we did this additional segment. I learned so much, and I'm sure our listeners from all over the Pharmaverse are thanking you as well.
Whatever I can do for the Pharmaverse, it's near and dear to me. So if anyone has questions, of course, reach out anytime.
Thanks again. And
of course,
many more great leaders coming up in the Pharmaverse, so stay tuned. Thanks for joining us on the Pharmaverse podcast. Make sure you subscribe below so you don't miss any leadership insights. Like and comment. I would love to hear from you. We'll see you on the next episode of Pharmaverse.